and the foundation and association formulas in Turkey have significant shortcomings in this respect. The use of religious titles forms part of the internal affairs of belief groups and should not be it should not be an issue that is regulated by the state. In Turkey, certain religious titles, mostly used by the Bektashi tradition, are banned under an old law adopted in 1924. Although this law bans numerous titles, few people have been penalized based on it. And even though there is no domestic legislation that regulates the use of other religious titles, administrative warnings have been given in cases involving the use of certain titles. There is no legal provision that prohibits the Greek Orthodox Patriarch from using the title ecumenical or requiring the Armenian Apostolic Patriarch to use the title Patriarch of Turkish Armenians. Public authorities have also warned the Chief Rabbi to change his title to Chief Rabbi of Turkish Jews instead of Turkish Chief Rabbi. Similar interference occurs in relation to the election and appointment of the religious heads of the so-called Lausanne minorities. In Turkey, different rules apply to the appointment of religious officials based on their religious affiliation. The Directorate of Religious Affairs appoints imams who work in mosques. There have also been interventions in the appointment of non-Muslim high-level religious officials of the Armenian Apostolic Church, the Greek Orthodox Church, and the Jewish community. These interventions are not based on law, but what may be called an established practice by the state. State officials have indicated that priests who work in the General Synod of the Greek Orthodox Church must be Turkish citizens. Officials also stated that members of the Greek Orthodox Church could apply for Turkish citizenship. Yet there is actually no legal basis for a requirement that the members of the General Council must be Turkish citizens. And the second sphere where the principle of pluralism is applicable to concerns the public religious services and facilitation of religious practices by the state. Turkey's unique state-religion relationship has always included the idea that state would assume the role of religious service provider, particularly in areas where the state holds monopoly. Perhaps this role is most visible in the Presidency of Religious Affairs and the provision of religious education in the school system. This may be also called the facilitating role of the state with respect to religion. With some recent legal changes, the state provided various types of religious services or facilitated them to a certain extent. These changes include payment of the electricity bills of places of worship that are recognized by the state as such, provision of religious education in prisons, and consideration of attendance at such education in the evaluation of good conduct of prisoners, and the problematic introduction of only optional Islamic religion courses in secondary and high schools. Discussions and governmental initiatives regarding the new constitution also indicate that the special constitutional status of the Directorate of Religious Affairs will remain in place. For example, the funding of the Diyanet's budget from the general state budget means that all taxpayers, whether they support the Diyanet's religious dogma, mission, and activities or not, do support the institution financially. And as we have seen in the case of, I mentioned, against Sweden, that this is not permissible. Similarly, funding of the Diyanet results in an unequal distribution of funds to belief communities. This also seems incompatible with neutrality as well as non-discrimination. A TESEV study found that 78% of those interviewed said that if the Presidency of Religious Affairs did not remain as a constitutional institution, it should be an institution separate and independent of the state. Only 21 said that it should be abolished and that each belief community should provide services for their members within their own means. I would just suffice to say that the existence of an institution like the Presidency of Religious Affairs, as such, is not incompatible with human rights standards. However, in the Turkish arrangement, certain elements of the Diyanet need to be rearranged in light of the normative demands of human rights law. For Turkey to comply with its human rights obligations, the government needs to carry out fundamental changes in relation to the Diyanet. However, as the state continues to claim responsibility for religious services as a service provider and facilitator, due to the existing problems in the implementation of the principle of neutrality, this is likely to lead to the deepening of discrimination. State monopoly over religious education continues to be an obstacle before the flourishing of the autonomous existence of belief communities in Turkey. Only the state can open religious educational institutions. As is well known, it is not possible to establish educational institutions that teach religion privately. And the state teaches only Islam. This does not reflect the religious diversity within Islam, as well as the diversity outside of Islam. And as a result, religious communities cannot train their own religious teachers, religious leaders, as well as their own communities. The recent democratization package had raised expectations for the resolution of this problem, which would then also lead to the opening of the Halki Theological Seminary, but this has not happened. To conclude, Turkey is not a theocratic or confessional state. It's a secular state with significant human rights commitments in the sphere of religious freedom. But Turkey is struggling with protecting the right to freedom of religion or belief fully for all, the obligation to comply with the principle of neutrality and to ensure pluralism. Many aspects of religious freedom inevitably require state regulation and decisions of public authorities on a daily basis. And where there is a lack of solid commitment to state neutrality and pluralism, which is inseparable from democracy, the protection of freedom of religion or belief will suffer. And as a result, human beings suffer. While the changes that are necessary to create a legal framework that will bring about the effective protection of religious freedom for all, including believers and non-believers, members of majority and minorities, the changes that are required for this seem obvious. The real issue seems to be to bring about a fundamental change of mentality that will embrace these necessary changes. Turkey's political parties and vibrant civil society, which includes our belief groups, will continue to have the change to bring out this change in the context of the new constitution. Otherwise, discrimination is bound to become more pervasive and deeply entrenched in various aspects of life. I thank you.